I'm really excited to talk about this interview because you can really not learn anything more about our jury system than hearing from jurors themselves, than listening to what the jurors have to say about sitting in that seat. We can sit here and pontificate and discuss what they're going to do, how they're looking at it, what they like, what they don't like. But this is how we actually learn, because they tell us, and this juror in the interview shared so much. I'm not going to make fun of them. I'm not going to call them an idiot. I'm not going to call them an inbred and they don't understand what's going on. I'm not going to do any of that. Okay. That's not my place, not my vibe. I don't do that to anybody anyways on YouTube. But to me, this may be the most shocking take right here. I'm going to give it away right here. This might be the most shocking take because it got so many messages and tweets saying, Peter, you're going to be floored. You're going to be so shocked when you hear this juror interview. Specifically, somebody said, the way this juror shows massive prosecutorial bias will shock you. Guess what? I was not shocked by almost anything that was said in this interview by this juror. And I said off the top that you guys didn't hear. Turtle Boy is the one that conducted this interview. It's on his page in totality. We don't have time to listen to all 3 hours of it. We're going to listen to some snips and discuss some of the really important key takeaways. But as somebody who clearly and right up the front says he supports Karen Read, this, in my opinion, was not a bulldozing interview. He was not pushing his way down this juror to try to get this juror to say anything that would make him look good, would make Karen Read's side look good. I didn't feel any of that. I felt like this was a guy who sat there, probably bit his tongue a little bit if I had to guess, but just wanted to learn and wanted information. And because he did that, we all have more information now to watch and learn from together. I'm sure this is right in YouTube's optimization to have a 3.5-minute intro, half of which my mic was muted, but let's play it because we're going to get into this interview now. All right. So we have, I guess I'll make myself smaller here. So we have, sometimes it's just weird when I'm talking and I'm in that little box. We have an opportunity here to take away what the jurors found important and what they didn't find important throughout the trial. And sometimes we're spot on and sometimes we're way off. And that's not just us. That's not just me. That's not just you guys. That's everybody. Every lawyer, every party, every juror, every judge. We don't always know what a jury is going to do. That's why it can be the best and the worst thing. And one of the scariest things that a lawyer can do and that a person can do is putting all of their eggs in the jury's basket here. But throughout Karen Read's interview, which I know they dropped the longer unedited or whatever the longer version is, we can talk about that another day. But we put our prosecutor hat on, right? And we think, okay, a criminal defendant is speaking out. A criminal defendant is giving an interview. What can the prosecutors use from this potentially in her second trial? And that was one of the focuses when I did that video. So now that we're going to watch this video and after watching this interview, I think it'll be important and a really good learning opportunity for us to say, what can the defense learn? Because I think there's a lot of things here that may alter the way the defense looks at the case. And at the very end of the video, if anybody doesn't care to see it, they don't have to stick around for it. I'm going to sit and give you kind of a little bit of a very brief outline or overview of how I would do a closing argument in this case based on what this juror said and based on exactly how I felt going through the first trial. And people have hammered me and come at me, and I get it. Say there's a conspiracy, say she's absolutely innocent and you know it, say it wasn't her, et cetera, et cetera. I don't know, I wasn't there, but I can apply legal definitions and standards to where I got in this case and where I continue to be in this case. And I think that's how I would pitch to a jury. I would treat them like I was talking to myself, like I was talking to you guys. And that's how I would lay it out. And I feel like there's even more push behind that kind of a discussion that I was talking about a lot through the first trial. And I'm going to discuss that at the end after we listen to this interview. So there were, and I know people were sending me, oh, Turtle Boy's leading questions. I actually thought there wasn't a lot, but there were a few questions that were absolutely leading. And some of them seemed to come from a prior conversation that these two had, right? We know Turtle Boy had talked to this juror before, had reported on it, had tweeted about it. So I think he was trying to get this juror to re-say some of the things he said, kind of like I do with my son. It's like, hey, Maverick, when he was little and he would say something cute or mispronounce a word, he would say it. Then I'd turn on the camera and be like, hey, say that again. So there was some of that. And this juror, which I appreciated, wouldn't just say yes. He would say, well, I actually thought this, or I actually thought about it like that. And And that's all Turtle Boy I felt like was trying to get. I don't know why the name Turtle Boy makes me think I'm offending him. I know that's what he goes by, but we'll call him Aiden as much as we can, or Turtle Boy. But I thought from my perspective, most of it was just trying to get the juror to tell us what he saw, what he thought, and what the rest of the jury was doing at the time. But overall, he did want to get out. Do you basically think Karen's innocent? Do you feel bad? Do you feel like this is unfair for her, that you guys really weren't allowed to speak up when you wanted to? And we're going to listen to some clips now of the interview.
That if they were in that situation and they were not being allowed to talk to the judge, they would say, well, too bad, they would make a bigger stink about it. How did you feel about that? Do you feel like after this happened, do you feel badly for Karen Reed that, you know that she was acquitted? You were in that room. You guys all voted a bunch of times. And, if you had just known, if it had been communicated to you better, if, you're not, the whole thing just seemed like you're not professional jurors. That's the way one of the jurors put it, is like, I'm not a professional juror. It's my first time doing a murder trial. I don't know how this works, but I know
there are no professional jurors. That's one of the things that makes it great and makes it really difficult, is that there are no professional jurors. The only professional jurists are judges.
We acquitted her, and this seems like a technicality. Do you think Karen Reed got the shaft?
Yeah, I think it's totally unfortunate because we just weren't well informed. And you're right, we're not professional jurors. We don't know how the law works. And it's kind of sad that, or unfortunate that we don't have that kind of view from an individual. So if we're in law, we would know how it's supposed to work. But from somebody who's new to becoming a juror or being a juror, we wouldn't know how the system really works. Mm-hmm. So it was very unfortunate circumstances.
Yeah.
So you're not supposed to have somebody that's an expert in the law on the jury. That's why it's hard for lawyers to get on juries. It does happen from time to time, but that's part of just how this system works. And I will tell you, while this interview will not change the outcome in case number 1, but what it will do, I will take this myself. I will just tell you, I will remember this. I will take highlights of this and quotes from this, and they'll be burned into my memory. I'll take notes on it, and other lawyers will too. And they'll go back to their individual states, their jurisdictions, wherever they work. They'll take them to subcommittees and different committees that they work on, rules committees, and we will try to get better. How can we inform the jury? The point of jury instructions is to take care of this problem they just discussed. You're not experts. You're not legal experts. You're not juror experts. You're not supposed to be, and we all know that. That's not a surprise to lawyers. That's the point of the instructions. So if the instructions aren't good enough, we need to make better instructions. Now, we'll talk about, when they get to later, about what they think the lawyers might do in the second trial. I may disagree with some of that, but they talked about whether he was fearful of McCabe's and Alberts showing up. He said, not really, maybe intimidated, but nothing was that big of a deal. He was an EMT, would focus on the patient first, but if he heard somebody say, I hit him, he would tell the cops. He has treated motor vehicle accidents before. So there is a theory, as we listen to somebody that has some scientific testing, and they discuss a nurse, and how a nurse also talked about how these, this accident wouldn't necessarily line up with those injuries. So there's one side, maybe the defense wants more medical jurors or engineers. But on the other side, when we hear them talk about some of the experts, they put some of their own knowledge, expertise, training above what the expert said, which again, didn't shock me at all. We'll get there, but I've told you guys a lot the story of when I had a case, and it was all about this one MRI, and we had board certified radiologists testifying to what was shown on the MRI. The jurors who didn't have any medical training wanted to look at it with their own eyes. So that's why it's hard to figure out who is your perfect juror. All right, so this is one of the bigger chunks of the interview that I wanted to watch through. We'll pause it, we'll discuss it, I'll answer your questions, etc. But there's a lot here.
Yes.
Okay. So what is the protocol? Like, what would the protocol in a situation like this be? Do you think that the police and the first responders handled this in a way that you would expect it to be handled? Like, not as far as not putting crime scene tape up or anything like that?
I don't think it was as coordinated as it should be. And I don't know if that's a fault of necessarily each individual or a problem with the system, in that maybe they didn't have the proper training, or they should have asked more resources to actually make sure that it was done well. But I have to admit, it does not seem like it was done well in any way, shape, or form.
So are you?
So that explanation of how horrible this investigation is was not as appalling as most of us who were looking at it, who may either know that that's how it works and how you're supposed to do an investigation, which maybe the defense, Ashley said top 3 things the defense needs to do differently in the next trial. So at the end, I'm going to go through even more than 3, but one of them may be, we've seen this in other cases. I think it was the YNW Melly case where they had somebody come and testify how investigations are supposed to go, how you're supposed to gather evidence, how you're supposed to store it, what the point is of chain of custody. So you describe and explain why it's important, not just that it was a bad investigation. He said it was really unfortunate. It's like, no. It's not unfortunate. It's over when you have a bad investigation like this. Chrissy said, I was a juror on a M trial and ended up as an alternate. Disappointing. After the guilty verdict, I was able to talk to the others, and it was clear they didn't understand instructions for joint venture M2. Yeah. And I got to be honest with you, like usually, and I'm saying this to myself, this is how I would feel if I got this report from a juror on a case that I tried as a trial lawyer. I would feel like it was my fault. It is my job to explain to the jury exactly what to do and how to do it. That's a lawyer's job. Avalon said we need a better education of our system to the general public, not necessarily professional jurors. I agree with you. I agree. It's part of what we try to do here, right? A little snippet of society that may happen to listen.
Qualified to look at a person's body after they're deceased and determine cause of death? Is that something you're familiar with as an EMT, or is that not something you're trained to do?
That's not my forte. I'm not necessarily, all I know is based on what is provided to me in terms of evidence, but I'm not in any way, shape, or form a educated person on pathology.
Well, luckily, there were 2 experts provided by the federal government from a company called ARCA that testified, 2 doctors, and they were the last 2 witnesses to go. And they both testified that, according to the physics, the science and the physics, the injuries to John O'Keefe are not consistent with being hit by a car, and the damage to the vehicle is not consistent with hitting a pedestrian. And so those guys are, doctors, PhDs, they do this for a living, etc. And in order to find Karen Read guilty of manslaughter, you have to listen to the ARCA experts and say, I don't believe them. So how did 8 jurors reach the conclusion that those guys didn't know what they were talking about?
It was as a direct result of Karen was there at that time, and John was there at the time, and it was believed that John died there, therefore, right, at that location, and therefore it seemed like, and everybody, all the witnesses were suggesting that he was never inside the house, and as a direct result, the assumption, or if you connected the dots based on the evidence that was provided to us, it seemed like there was some sort of collision with the car, and therefore there was damages to the vehicle. And with the damages to the vehicle, and that both individuals were there and present, that the cause must have been, or somehow some sort of involvement by Miss Reed.
That right there. And if you guys want to back it up later and go listen to that again, that sums up what the jury felt, at least the ones that were voting guilty. That is not surprising to me at all. They're like, they were both there. There was a car. He ended up dead. I could have added, and she is sitting over there in that defendant's seat. And all these cops and all these prosecutors seem to think she did it. Who are we to say she didn't? That's how so many jurors walk into jury duty. I don't care what they say. And I think I'm not blaming them, right? That's just kind of like the natural proclivity of a person to think. Most people grow up and that's what cops do. They arrest and get the bad guys. So it's like, I heard a lot of assumption in there, and kind of seemed like he didn't go inside the house, and damage to the vehicle. So there was at least some thought that the vehicle caused it. Occam's razor, right? Jackson said that in his closing. And right when he said it, I was like, kind of sounds like the simplest explanation is that he was hit with a car. Hi from England, a fellow Greek here, first ever live. The jury interview was shocking to me. How does anyone put on a defense that is called distraction? If I'm ever accused, bench trial, please. Oh, no. There's a reason that the best and most experienced defense lawyers almost never pick a bench trial. And I would be, they're not doing it. I'm just telling you, there's not a lot of things I say are guaranteed. I can guarantee you they ain't doing a bench trial here. You're much more likely to get an acquittal with a jury than a judge. Michelle, how does the time for closings get decided? Can it be argued if not given enough time? Absolutely. It's something we fight about it. There's a trial order that says how much time we're given for voir dire, for openings, for closings. Usually lawyers fight for more, but I also think like ASAP Rocky's case, I think the closings were too long. Like I think in a case that's a really long case, I still don't think you should go over 2 or 3 hours. I know they were limited to an hour here. And somebody asked the question, what do you think for an hour for closing? I think if I was a judge, I would say the max would be 1 hour per week, but you don't want to give an 8-hour closing or a 3-day closing. So I think 2 or 3 hours, you should be able to get anything you need in 2 or 3 hours, or else the juries with our time span, they're not going to, our attention span, I don't think it's going to be effective. Michelle, I think it all comes down to the fact that they didn't believe J.O. ever went inside the house. Therefore, the only person with the opportunity was KR. Au contraire. Oh, no. Because this juror is going to say something that I said a bunch and I got hammered for, and it's fine. And I get it. And I understand why you guys, or at least some of you that feel the conspiracy is 100% truth. I understand your frustration and I understand the discussion. But that we'll talk about that more when we get to what I would do different in the closing arguments. Thank you, Rebecca, for gifting 10 memberships.
So that was how they all arrived at.
But how did they reconcile? Was the ARCA testimony brought up by the people that thought that she was not guilty? Did they, I'm sure somebody in that room must have said, but these experts are telling us that that's not possible. And what was the answer to that? Like, did people say that that these guys are bullshit artists, that they're fake doctors? Like, what was the reason not to believe them?
I think the major rebuttal was, we don't know. And that was the other thing. It was very ambiguous on why these individuals were testifying. And so there was a question in the group on their essential integrity in terms of, were they there as a direct result of somebody else trying to steer us in a different direction?
So they were worried about the integrity of the ARCA witnesses because they were not hired by the defense. And was somebody trying to steer them a different way? Pay attention, and I'm going to mention it multiple times. It was very clear the prosecution did an excellent job of planting in these jurors' minds that somebody is trying to trick you. Somebody is trying to distract you. It's all smoke and mirrors. Pay attention to what is the simplest explanation, as Lorraine said. Don't get distracted. And they were like, huh, how offended are we? We're not going to be tricked. We're not going to have anybody pull the wool over our eyes. And most people don't want to be duped, especially if they're doing something that's very important, which these jurors were. Cassidy said, I'm still waiting for my ASAP update. It's coming, Cassidy, sooner than you may think.
And confused the jury. So it wasn't sure if it was insurance. It wasn't sure if it was, whether the Reeds were doing it, somebody else was doing it, or yourself was doing it to bring this group to try to testify so that it would sway.
So they didn't know if Reed's insurance was doing it. Somebody else was doing it. Even though they said nobody on behalf of Miss Reed, they didn't believe the defense, which there's a lot in here that just makes me think they didn't give a lot of credence to what the defense was saying. The defense lawyers specifically. Ashley said, what question would you have wanted to ask the juror? I really think most of the information came out. I would have followed up right here. It's interesting. This question just popped up while we're at this spot. I would have followed up with, how did you hear about me? Who did you think I was? Who did you think Turtle Boy was? What did you know about me? What did you think I was doing? I was obviously in the courtroom. They talk a little bit about, he and Jen McCabe, but what did the jurors think about him? What did they know? And with that kind of inquiry, none of them went back and did any research or anything like that. Just interesting. Okay, so Lisa, good point. When the first Twin Tower went down, Occam's razor was dictated it was an accident. That doesn't mean Occam's razor is always true, but Alan Jackson made that argument in his closing. And again, a lot of people seem to say their side is Occam's razor. Their side is the easiest explanation, but it's not really always that cut and dry. And it doesn't always make it true, okay? It absolutely doesn't always make it true. I agree with you there.
The jury in one direction or the other. And that, I think that was one of the things that was, again, unfortunate, because I guess it cannot be said or didn't want to be revealed to us on what were the circumstances of why those individuals were testifying, other than they were testifying for the defense.
Because now you know. obviously now that the trial's over, that they're not even defense experts, they're FBI. They were available to both sides, and only the defense called them. But it seems like the conversation in the room went, and they said some people were suggesting maybe they were the insurance company, of course, because of course an insurance company would benefit from not having an automobile collision. Obviously, they wouldn't have to pay anything out. Or me, how did people thought I paid the ARCA guys? That's wild.
Like anybody, somebody was trying to, again, to try to sway the jury in one direction versus the other.
I'm not that powerful, I promise you. I can't afford those guys. But so that's basically the reason that they came up with. They said they heard all their testimony, and then they said, nah, those guys are just probably paid off by the insurance company. We're going to disregard everything that they said.
Which even that is crazy, because it's like both sides was paying experts. It just, to me, this feels a little bit like the jury searching for reasons to discredit the defense experts because they had already decided that the defendant was guilty. And I think that's, part of the problem we try to deal with as criminal defense lawyers. They get to go first. They have the burden. But because they get to go first, we have to hammer that burden of proof as criminal defense lawyers. And the just wait, stuff like that, you've got to press that, because jurors make up their minds way too early in a case. And then, as I say in every case, if they're with you, it's easier to put your arm around them and bring them along the trial with you as a lawyer. And once they were with the prosecution, I don't care what anybody says about, including myself, about the presentation, how it wasn't the strongest or most eloquent presentation. If they're with him, they're going to start thinking the way he sees things is the right way to see it.
And one of the other reasons is because there was the other testimony of the individual from the dog bite expert and all of the other things that the defense was trying to bring up, that again, wasn't sure if it was just to try to confuse or sway the jury in one direction versus the other, or create a jury which was created reasonable doubt, and therefore
That's exactly what they were trying to do. They were trying to sway the jury and create reasonable doubt. That's what defense attorneys do. But he says it as if it's a trick. And someone told him the defense was trying to trick him and distract him. Yeah, prosecutors say that every case where defenses actually have an argument. None of it matters. Don't look at it. Don't be tricked.
vote had to be in one direction versus the other.
So it sounds like what you're saying is that some of the jurors in the room were saying that all of this defense third-party culprit thing, a dog biting John, this is all bullshit. This is all a smokescreen, and all these people, this dog bite expert they're bringing in, this is all a distraction from the fact that Karen Reed ran John over. Is that an accurate portrayal of what people were saying in that room?
That is correct.
Wow. Okay. So in order to believe that Karen Reed killed John O'Keefe, you have to believe that, and that John O'Keefe didn't go inside the house, you have to believe all of the McAlberts who testified. And so am I correct in saying that they found the McAlberts to be convincing witnesses and truth tellers?
Correct. And I will say that that's just...
And this is another lesson, right? Especially when people know so much in the background and they bring it to the table, and that's how they're looking at these witnesses versus somebody who just meets them that day. I tell my clients this all the time. I say, listen, you're an amazing person with an amazing background. These 6 people or 12 people are not going to know who you are. They're not going to just automatically believe you. So if there are some holes or inconsistencies, we need to deal with them, right? But once they start to believe you, once they start to believe a witness, me and Dave Nizer, my firm specifically, talk about this all the time. So he's really good at pointing out the problems in our case, right? He's like, oh, we got to deal with this. This is a problem. He's good to make sure that whatever the other side's seeing, he always sees as well. But the thing we always come down to before we try a case is, if the jury's with us, they're gonna be with us. They're gonna believe this expert. If they're not, they're gonna look for ways to diminish it. We know this. This is what happens in trials, and that's what we're finding out through this interview.
Some respect, not only to say it's correct, but also to some respect, because there were some individuals who just looked at the facts. Again, the clear fact that Karen was operating a vehicle and drove the vehicle to that location, 34 Fairview. Mm-hmm. And then ultimately John O'Keefe lay at rest and died on essentially that address. And so everybody else is saying that he never entered the premises, therefore she must be at fault, because he clearly did not just injure himself there. So
did anybody suggest that maybe the McAlberts are not being truthful, that maybe he did go inside? I mean, I assume somebody in the room, the not guilty voters, must have said that these people are lying, obviously. And what did people say to that? I mean, did some people believe at least that they weren't being honest?
I think the individuals who believe that she was not guilty was because of the mere fact that it was not adding up. So the injuries to John O'Keefe ultimately did not add up to the damage to the vehicle.
Mm-hmm.
And what ultimately injured him was, or led to his death, was a injury to his head, which was not very clear that that type of damage could have occurred on the vehicle. And there was no damages on the vehicle that would indicate that kind of situation. So for those who were skeptical, that's what they were looking at.
Yeah, the Commonwealth alleges that that his arm, I still can't believe they said this theory, that the arm was out and that the arm is what caused the taillight basically acted as a knife and just sliced his arm up and then caused him to spin and then land 30 feet on the grass. And the gash in the back of the head came from hitting the grass, which they said was so hard that it somehow caused a gash in the back of his head. People really believe that?
Yeah, I mean, I don't think a lot of people in the room, some people who were experts in science, right?
Some people in the room who were experts at science
and physics, or have some knowledge of physics, necessarily believe that as the case, given the circumstances, that it was not very clear.
Mm-hmm.
But again, some individuals just believed at the circumstance that Karen and John were there at the same time, and John ultimately was killed.
And the text stream data is what you mentioned.
And sometimes that's all you need when you're a prosecutor. They were there at the same time. Somebody's life ended. They're pointing the finger at her. It's good enough for us. And you can hate on this individual juror all you want. There are a lot of jurors that think that exact same way, which is why the system and rules are set up the way that they are to favor defendants, because those of us who write the rules and talk to the people who write rules and edit rules, we all know this. We all know this. Ryan Nagel and crew placed Karen alone in the car, intact taillight by 12:23. OJO took his final steps stairs. Isn't that crucial? What's crucial to you might not be crucial to this jury. And that's the point. And if the devil's in the details, you as a lawyer better explain why each one of those details is absolutely true and important to prove X, Y, or Z.
To me a lot last time, and you said that was what the guilty people really stuck to, was the text stream data. What was so convincing about the text stream data for them?
It was a combination of the speed, and suddenly there's an increase in speed and a decrease in speed, consistent with maybe somebody backing up, and so that, looking at that, was kind of convincing that she must have accelerated in a backwards motion, and then
even though that 24 miles an hour in reverse 62 feet thing, there was no time associated with that. It was measured in what's called key cycles. And
this is what we call making reasonable inferences from the evidence and connecting dots. Turtle Boy's giving some specific details about how that wouldn't work because they didn't give it time, so it wasn't proven beyond a reasonable doubt. We'll talk a lot more about what that definition actually is in Massachusetts when we talk about closing. But I can't tell you, since I've been doing YouTube, multiple jurors have reached out to me and I've talked to them kind of off the record. I don't really want, if they want to come on and talk, sure, I may do something like that. But a lot of them are like, hey, can I just talk to you about it? I'm like, sure. After the case is over, not revealing anything that would make an appellate issue. But so many of them find reasons to explain away gaps in the evidence, issues, by making reasonable inferences or connecting dots themselves in their head, regardless of whether that evidence was actually produced.
And they couldn't explain, like, at least they didn't say for sure, like, this happened at 12:32. For all we know, that event could have happened at another time or another place, because they didn't give us a time. But people were pretty convinced just based on that alone that, yeah, that's proof positive that it happened at that exact same time?
I think it was a combination of, again, the circumstance that both individuals were there. There's evidence of a broken tail light, the injury to John, and the injuries that John sustained. And then ultimately, that texting data was just another piece that indicated, yes, there must have been some movement. It was very interesting.
Also, this reminds me of when we're prepping for trial. So a lot of this is coming to my mind, which I'm happy about, right? It's tough, but with information, you grow and you learn and you can get better. And one of our things is tell a simple story, because in the civil cases that we are prosecuting, we want to tell a simple story. We don't want to get lost in these little minute details, because when you do, and a jury either gets confused or they're like, are people trying to trick me? Or, two experts disagreed on this, detail that's very scientific, but you have a big picture, simple story. Sometimes that can carry the day. Sometimes it can be really frustrating if you don't believe the simple story, but you keep hearing him say, they were both there. We know the car went backwards. We know there was drinking involved. And we know John O'Keefe died. He keeps saying that. He keeps saying that, regardless of timelines, regardless of the investigation. I mean, the fact that he's not saying the whole time, yeah, but the investigation. But what can they actually prove because of the investigation? That can make your head spin.
Interesting, though, it wasn't very clear, and I think I said this last time, that it would have been nice to have somebody who is an expert in that, or somebody who has knowledge of that type of data from that company, right? From Lexus or whatever company, right? And to provide some information on if that can be accurate and what causes it to actually occur.
So they thought they should have gotten more information from Lexus or somebody like that. And who do they hold that against? Who do they hold that against? Not the state. It's like, if they didn't give you the information that can prove exactly when she backed up, who do you hold that against? The state. It's their burden. That has to be drilled into a juror's head. It has to. Ozzy said, Peter, if you had a mistrial, I've had a mistrial. I've had a hung jury. I've had all the different things you can have in a trial we've had.
For example, like I was saying, or I was thinking, like right now, as I'm driving home, right, my car could have slipped, and that could have triggered something, right, to suggest that maybe that will make a trigger that I'm driving kind of erratically, but it's not because of me, it's because of the ice and the snow on the roadway causing that to occur, which we all know that during this time frame, that's the type of weather that was being experienced by Karen and all individuals, I should say, during this time frame.
So if the defense had an expert from Toyota or whatever that could explain, like, is there anything that could make it look like you went a certain velocity and you really didn't? Maybe your tires were spinning, maybe the RPMs were up. That would have been a good witness for them to call.
I think that would have been helpful.
Yeah, sure. There's a billion things the defense can do to prove every little detail. But once again, what if they would have called that? I would be willing to bet and guess that this jury would have said, at least the ones that voted guilty, that's just another distraction. They're just trying to distract us. We know she went backwards. They said it. It makes sense because she backed into him. Her back taillight's the one that's broken, not her front taillight. It all just makes better sense the way the prosecution's explaining it. I think that's what would have happened, even if they would have called a Lexus expert. You've got to draw the line somewhere, right? You can't call 100 witnesses for every little detail that every individual person thinks. You've got to pick your best arguments. And again, when we talk about kind of how I would break it down to simplify it as the defense at the end, again, they know what they're doing. They're smart. They're more experienced than I am, done more trials than I am, dream team, all that stuff. So I'm not saying I know anything better than them. It's just, to me, a simpler way, as somebody who does not know everything about this case like these people do, like the defense lawyers do, like some of you do, just how I think it's simpler to think about in my head.
This definitely would be a helpful piece.
Okay. Let's talk about reasonable doubt. Going back and listening to it all, the defense gave you this story about what they think happened, how John O'Keefe went in the house, he was beaten up, and he was left outside to die on the lawn, and then Karen Reed was framed there after the fact. All right. And what I didn't hear much from the defense in their closing arguments was about what reasonable doubt was. Did you guys discuss?
And this is the big question. And this was kind of my takeaway the whole trial. Everybody wanted to talk about whether or not I believe the conspiracy. And I think everybody got a little too swept up in that. They want to know. And I said the whole time, I don't have to get there. I don't have to get to, was there a conspiracy proven? And that pissed people off. And that's what everybody was trying to prove. And all the focus was on, when in reality, you just have to show reasonable doubt. Then you win. And I'm telling you right now, Karen Reed doesn't care if she wins. She shouldn't care if she wins on conspiracy, if they think she's innocent, or if they think the investigation was so bad they could never prove it. She gets to go home and go on with her life. Now, in the court of public opinion, sure, prove the conspiracy, prove innocence, all of that. But in the criminal justice system, not guilty is the same whether you're innocent or it's not proven against you. And that's why I tried to stick to that answer. And that's what I think is the most important element of this case, is reasonable doubt.
What reasonable doubt was in the jury room? Was that made clear what that was? Because how, some of the things that you're saying right now is reasonable doubt. Even the arguments that Karen Reed, from the people that believe Karen Reed is guilty, they're making arguments for reasonable doubt. Did you guys understand what reasonable doubt was?
I believe we did. And
of course, they think they understood it, right? Everybody, if you tell them what reasonable doubt is, they think they understand it. But everybody has a little bit of a different, I'll just tell you right now, and I'm not calling him stupid or any of the jurors stupid by saying that, because guess what? We try to argue what reasonable doubt is sometimes and get objected to by prosecutors. They try to argue what it is, and sometimes we object to them. So even lawyers have different definitions of reasonable doubt, but everybody thinks they understand what it means. But it's your job as the lawyer to try to explain in closing argument to this jury what you believe reasonable doubt is. And if the judge doesn't correct you, then that is what reasonable doubt is.
And that's where we kind of essentially got stuck, is because I think that's why it ended up as a hung jury, is because we kept rehashing that second charge, in that some of us felt there was enough reasonable doubt and some of us did not. And not that we're trying to coerce anybody or try to convince anybody to vote one way versus the other.
But did they understand what reasonable doubt was?
I think everybody had a clear picture of it. That being said, I don't know if everybody wanted to vote in a particular way based on reasonable doubt.
Like, what does that even mean? Right? I think we all had a clear picture of it, but that doesn't mean we wanted to vote a reasonable way or the same way on reasonable doubt. Okay. If they would have known about the federal investigation, it probably would have swung more votes, obviously. That's exactly why they can't know about it, because it would be prejudicial. But just because there's an investigation does not, we all know what it really means, but it does not tend to prove or disprove a material fact in the case. Therefore, it's not relevant to that trial. So it doesn't come in. But the fact that now they know that negative inferences were made, almost more negative. It was almost worse that it was an independent third-party agency that hired these experts, rather than just saying Karen Reed hired them, right? Like, they're going to have to think about whether or not they just call them their own experts. Or even they need to hammer home, no doubt about it to me, they need to hammer home that, and I would go through the list. I would, if the judge would let me. Karen Reed didn't hire you, right? The law firm didn't hire you. Karen Reed's insurance company didn't hire you. None of Karen Reed's friends hired you. None of Karen Reed's family hired you. None of Karen Reed's supporters hired you. Nobody with any connection to trying to help Karen Reed paid you $1, did they, sir? I would ask that to both. I would take the time with it. If the judge didn't allow it, I'd fight. And eventually I'd do what the judge told me I had to do. Christy, not sure if you've covered this yet, but did you see Beto has joined Karen Reed's defense team? Yes, I did. Good for them. Team grows stronger. Anya said, if asked, would you join the defense team? They do not need me. They have plenty of experience and very good lawyers that can handle this case.
Now
Actually, I'm going to jump a little bit ahead here.
Killed him. But you mentioned the taillight. That's the only real physical piece of evidence that they had against Karen Reed. However, was it brought up during deliberations that the Canton police searched the scene at 7 a.m. with a leaf blower, and they videotaped it, and they didn't find a single piece of bright red taillight on the snow, yet they found 45 pieces over the next few weeks. Was there any discussion that perhaps taillight might have been planted?
There were some individuals that were definitely stuck on that and believed that was reasonable doubt, but there were some individuals that believed that it made up, again, just circumstance or happenstance, that maybe there wasn't enough snow at the time, and therefore now...
it was just circumstance or happenstance. Michelle said, also, he heard the ME pathologist say they couldn't determine how JO's injuries occurred, but then gave the benefit of the doubt to the Commonwealth. Yeah, I want to put your question up because it's the same thing they did with the taillights. They just gave the benefit of the doubt to the Commonwealth, which they normally do, which the defense felt in this case they had enough shenanigans and crap going on in the background that they could prove frame job. They obviously did it, et cetera, et cetera, et cetera, which is fine. But what this juror did agree with, and I bet most jurors agreed with, it wasn't a good investigation. It wasn't good evidence collecting. They didn't handle this case well at all. You have that. That's almost locked in. The prosecutors almost apologize for it and agree with you for it. Use that. Use that to prove reasonable doubt as opposed to using it to try and prove a conspiracy. You can mention the conspiracy. It can be part of your argument. But the reasonable doubt is locked and loaded because I really think they believe the investigation sucked. And regardless of how horrible cops are and the corruption, there's a question coming up about Birchmore. We're going to talk about that a little bit. Jurors usually want to believe prosecutors and law enforcement are doing the right thing. Doesn't mean they are. And you can be mad at me for my comments if you want. I don't think a lot of you will be. I'm just telling you statistically how it normally is with jurors I talk to. In my cases and in other cases.
Ultimately, now the ground is covered and therefore you couldn't see the pieces because it's covered. But prior to that, maybe now you can see it. So,
well, it would be the opposite. Because when the Canton police got there at 7 o'clock, there was 3 inches of snow on the ground, tops, maybe 4, 3 to 4. And it's a lot of taillight, right? And they had their leaf blower out, and they have a video of him finding these transparent pieces of cocktail glass. Paul Gallagher finds them. So they were able to find transparent pieces of cocktail glass, but not all that red taillight. Was the general consensus that the Canton police are just completely incompetent? Wouldn't they have to be if they didn't find any taillight? Was that the consensus?
I don't think that was the consensus. I think the consensus was just, again, they looked at all of the overarching evidence, not just that one little piece. So individuals looked at everything. And
they looked at all the overarching evidence, not just that one little piece. Because jurors don't necessarily even, people just generally don't even know when they are making leaps, right? Without the broken taillight, there is a 0% chance they convict Karen Reed. They might not even prosecute if the taillight's not broken and they can't even prove there was a collision. So one little piece of evidence, giving them the benefit of the doubt, happenstance, whatever. But we looked at the totality of the evidence. I don't blame him for that. I think he believes it. I think the other juries believe they look at the totality of the evidence. But the truth of the matter is, that's the linchpin. That's the linchpin. So if you're like, it's pretty big, right?
And said, nope, that's...
Be careful what you say about this interview and about this juror if you want to learn more about what juries have to say, okay? Because we want to hear what jurors say. We want to educate better. We want to make jury instructions better. The only way we know what they struggle with is if they come out and talk about it. Because so often in the law, we assume jurors understood everything correctly. We assume the jurors did their job properly. We make assumptions. I would rather know. Even if it's bad news, I'd rather know and deal with it.
That one little piece. So individuals looked at everything and said, nope, that's not enough to say that created reasonable doubt.
That wasn't enough. We are going to jump. So people are asking if he was a guilty vote or not guilty. I believe he ended up not guilty, but he started not guilty and flipped. And I think this is when Turtle Boy asks him about, why did you flip? Because that's the point too. He's all locked and loaded that, she's innocent now. He does say he believes she's innocent now, but sitting back there, at some point he was convinced of her guilt as well. I can't tell you on a scale of 1 to 100, I am at 100 with appreciation and kudos at this juror for giving the interview and saying what he thought and explain to us what they thought, because it's real easy for everybody else to sit and know exactly what happened and know exactly how they would vote and know exactly what they would do, right? But I'm telling you, when I came into this case and knew nothing about it, it was not as cut and dry throughout. I got there, but I had the benefit of being online and watching it and rewinding it and comparing 2 clips. Somebody made a comment earlier, why can't we give them transcripts? I do like that idea. or maybe even letting them watch the testimony back if they want to. I am for that. And it's not going to happen tomorrow, but it is a conversation that I think we can start having.
Guilty.
From not guilty to guilty.
Not guilty to guilty. I think ultimately, again, some of us broke down because it was very clear. They clearly displayed that both individuals were under the influence of alcohol at the time, and therefore should not have been operating a vehicle. So
he's talking about what made him flip from not guilty to guilty. Daybreak brings this question up at the exact time. Jurors don't like drunk drivers. And again, Higgins and everybody else that was driving drunk or after drinking, they're not the defendant. They're not sitting in the defendant's seat. They don't have the spotlight on them. That matters. That is potentially the most important thing, which is why taking a different case like Kohberger, maybe you think he's guilty of sin. That's why on this channel, we discuss, let's presume innocent. Let's make every decision as if he's presumed innocent at this point. Now, there's probable cause. How does that change our decision-making? Fine. But this is why. This is what you are as a criminal defendant. That's why we say don't talk to the cops if you're ever accused. Not because that means it's guilty. And I didn't love how Karen Reed and her team said, well, all these witnesses talked with criminal defense lawyers. Why would they need that? I get it, but I don't like it. Because they knew they were going to be accused of crimes by Karen Reed. This is why.
The operation of the vehicle, and that is that second charge, which is involuntary manslaughter as a direct result of operating a vehicle under the influence of alcohol. So that is what a lot of people kind of swayed on, that yes, they shouldn't have been operating.
But that still had to cause the death, right?
In the vehicle, and it's not murder too, but could it be that she operated the vehicle negligently and therefore led to involuntary manslaughter? So that's where there could be a sway.
So it was the fact that she was, admittedly had. So I would say, so the testimony from the police about she had 4 drinks here, that was very effective, obviously, because ultimately they said, well, she was drinking and driving, so she probably did it.
I think it was not only that, but the video footage of the drinks that she was having was very strong in leading to that kind of opinion and thought process.
Okay. Even though the rest of them were also drunk. I mean, everyone was drinking and driving that night, including the police. And that didn't bother anyone else?
I think it bothered everybody, but ultimately we have to look at who's being charged here, and the individual who's being charged was Karen. So unfortunately, nobody else was being charged with it.
Didn't matter if anybody else was drinking because he didn't say this, okay? But this is what he means. This is what he means, in my opinion. The cops think Karen Reed did it. They didn't think Higgins did it. They didn't think McCabe did it. They didn't think Albert did it. So their actions that night don't matter. Karen Reed's actions matter. They all drank. Who cares? They all drove. Who cares? Were any of their cars tested? No. Was the inside of their house tested? No. Karen Reed's car was tested. Karen Reed's car had damage on it. When you sit in that defendant chair, what you did is what they care about.
Was just Karen, so therefore Karen must have been, and both people were there during that same time frame. So
that's interesting that you say that, because, and I've long argued this, that being in the defendant's chair is you're already losing. You're already down 20-0, something like that, because you're here, you've been charged, you probably did it, or else you wouldn't be here right now. So you would argue that the fact that she was charged at all and sitting in that defendant's chair and no one else was charged is pretty, that people were suggesting that was, pretty solid reason to vote guilty.
I believe that it was a combination of, so theoretically anybody, right, should be considered innocent until proven guilty. But here
theoretically, people should be presumed innocent until proven guilty. Theoretically. That's not theoretic. That's literally they're presumed innocent. Literally, they are innocent. And that's what I don't like about certain prosecutors who really dumb down or try to, diminish the presumption of innocence.
clearly the Commonwealth displayed that she was under the influence of alcohol, even though there was no breathalyzer per se at that exact time frame when
there was no breathalyzer per se. They did the worst alcohol extrapolation of all time. But guess what? They were the ones that did the extrapolation. They gave the big number. I thought the videos of her ordering the drinks and taking them and then the glass being empty later, I thought that was good evidence of her drinking. And that was enough for the jurors to be like, she's drinking, she's driving, her car's there, body on the snow, and her taillight's cracked.
and the incident occurred, right? It was after the fact. But based on the evidence of the receipts and the video showing that she was under the influence of alcohol and then operating the vehicle, that would be easy to kind of charge her with involuntary manslaughter, operating a vehicle under the influence.
Easy. It would be easy. It's not just like it was a struggle for some of them. It was an easy and quick guilty.
So I have a question here from another juror. Is actually from the one of the jurors who was not chosen to deliberate, and I'm getting a message from them now. And they said, this is the quote: "Did the jury ever discuss to a moral certainty as part of the reasonable doubt discussion, or would having an attorney in the room have been helpful for that?" Because I believe one of the jurors who was, randomly chosen not to be in the jury was an attorney. So would it have helped to have an attorney in the room describe what to a moral certainty was? Was that discussed at all?
I think having that level of expertise in the room would have been helpful for everything, including the fact that, number one, that.
So it's interesting that they almost had a lawyer on the jury, but from my perspective, yeah, that can go your way if they really explain reasonable doubt and that's what they believe in. But from my perspective, this is sometimes why lawyers are not wanted on a jury, because they become king or queen and they're the experts and they just tell people what to do. So sometimes you only have to convince that one lawyer and then it goes that way because they tell you how things are supposed to go. So it can be a good thing, it can be a bad thing. Hindsight's always 20/20.
All three charges could be looked at independently, and somebody who has that level of expertise to clearly indicate to us the moral certitude of reasonable doubt.
Okay, because
so no, never, ever, ever did I say ever, ever, ever that lawyers can't be jurors. I've had a lawyer on one of my juries. He was a civil lawyer on a criminal jury, but it's very, very rare. And I will never be on a jury because of the sides I've practiced on, and I won't ruin my jury duty experience that I did a little video that's coming out for you guys next week on, because I was recently called for jury duty. And what happened to me is the most common thing that happens to lawyers.
They went on to say that when we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs. So obviously, this discussion didn't even take place at all. You know what a moral.
So I won't say that it didn't take place because we read that statement multiple times to the group. I don't know if it hit home to the group more so if that individual was there to provide that level of expertise. Okay. So if somebody was there to provide that level of expertise, I think it would have been more realistic or tangible to the jury or the group rather than not. Because although it was read multiple times, and I will say that we read it multiple times, and I was one of the individuals who was reading it multiple times. It clearly may not have made an impact or have been as impactful as if there was somebody with that kind of experience and that level of knowledge.
I get it. And I think most jurors think, oh, it would have been great to have an unbiased lawyer, is what they mean, on the jury to explain to us how to do it. Because guess what? There are 3 lawyers at least that explain to a jury exactly what to do and how to do it. The lawyer for each side and the judge. That's what jury instructions are. That's what our job is as a trial lawyer, is to explain to jurors what this stuff is and what they should do. Sometimes we forget that. Sometimes we get wrapped up in the weeds and in the facts of the case. But it is our job to explain to a jury who's not professional jurors, because there are no professional jurors, what to do and how to do it. There isn't some lawyer sitting back there with them. Let me hit some questions here. If you were defending Karen Reed, would you appeal to the judge to allow read/watchback of testimony? Also, would you appeal for more time in closing arguments? Yes, to more time in closing arguments, but not a crazy amount of time. Not necessarily on the readbacks, unless they asked. If they ask, I would want them to be able to read it back. Emmy, do you think this will change the way the defense handles jury selection for the second trial? I think that this will affect who they determine as their ideal juror, because usually trial lawyers have what they think is going to be an ideal juror. I don't think AJ needs more than an hour. Keep it simple, stupid. J. Rose Gold, I love the visual that Weinstein used in the YSL closing and explained reasonable doubt really well. What have you found to be the best way to explain reasonable doubt to jurors? So my shtick is I try to make it seem like, and it is, the most insurmountable, highest burden of proof you could ever think of without it being a guarantee that you are there and watching it yourself. That's how much they have to go. And sometimes I get objected to because I make it seem like too high of a burden. And whenever a prosecutor tries to argue that it's too high of a burden, they stop the argument. And they're like, okay, never mind. It should be about as high as a burden as you can. I use different analogies depending on the case and depending on the jury, because we know the background of the jury once we're trying a trial. People that are under the influence of alcohol also fight. Isn't that a propensity, Rebecca? But it all depends on what side you're with. I bet some of the jurors that believe the conspiracy said that exact thing. Brianna said, why would you want to interview a hung jury? Sometimes, Brianna, that's the best jury to interview because it wasn't a consensus. They all didn't just think the same thing. There were differences of opinion. And what caused those differences of opinion? And what can we learn from that? He's saying to catch the middle charge, she only needed to drop him off at the place he was beaten to death by others. I don't think that's what he means, but it almost sounds like that would fit into it. Thank you, Rebecca. Yes, everybody hit that like button if you guys have not already. We've got a long way to go here. We got a long way to go. At least another 20 minutes, maybe 30 minutes. We're doing overtime, so hit the like button for that. All right, now he gets into ultimately, why was it not guilty for you?
That there was reasonable doubt.
Oh.
Caused you to believe in her innocence, or that there was reasonable doubt.
Ultimately, what made me sway back to reasonable doubt was, yes, she was there and he was there at the same time frame. However, the injury that ultimately causes death was inconsistent with the physics of the damage to the car. And the other piece that causes death was the hypothermia. So those two pieces, which was presented to us, was the basal skull fracture to the back of his head and the hypothermia. Was inconsistent with the damages to the vehicle. And so ultimately what I also thought about was that he was the one who kind of, and I'm not trying to put blame on him, but he ultimately was the one who was insistent to try to go back and go to this place. So before Fairview, he was the one who kind of programmed the GPS to that location. And she was the one who was...
He being John. He doesn't want to put blame on John, but he's talking about John O'Keefe.
Asking to just go and have something to eat. Granted, it was a pizza place that was closed. She wasn't really looking to go drinking anymore. At least it seemed like it. He was and continued to party. So not trying to put blame on him, but it doesn't seem like she is at fault of what.
So one of the reasons he came not guilty is because it seemed like John wanted to go to the house, not Karen. Okay. And again, if it would have been a not guilty verdict, all free Karen Reed and her whole team would have been like, yeah, okay, whatever it takes to get to not guilty. Because sometimes you never really know. But it was a big deal that John O'Keefe wanted to go back to Fairview and not Karen. It was a big deal to them. I agree with you, Charlotte. I feel like there are certain things you can tell, but yeah, I'm kind of taking it as these are the discussions the jury had. This is what's important to the jury. That's kind of how I'm talking about it, or how I'm taking it. They talked about if he thought anybody could be connected to McCabe or Albert on the jury. He said possibly, but doesn't know. He also thinks it was an honest jury and they did the right thing. He did find the butt dials were very hard to believe. That's good. Karen's facial reactions solidified it for some jurors, he said. And I don't think he meant solidified not guilty. I think he meant solidified guilty. And from my perspective, it's in a situation where I don't think they help. So controlling your facial expressions, Looking sad and whatever is fine, but controlling your facial expressions is really important. He thought it was a biased investigation, framed. He's not really sure, but he guesses the light was planted if it wasn't her who hit him. Then they get into the Google searches, and this is when, again, we hear some of that distractor or distraction language.
Did you guys discuss the behavior of the McAlberts and how suspicious it was?
We extensively discussed why was the first person to go to the house, approach the house, was member of the family, you know what I mean? And then the other pieces of the Google search, we don't know. And again, there was not an expert in the group necessarily that could talk about it with enough knowledge on experience. And
so they need an expert in the group, meaning the jury, to explain to them things that the defense hired experts and the prosecution hired experts to explain to them. It's not uncommon with jurors. I've literally had the same thing in trials I've had, where we've paid experts a lot of money, but the jurors looked to their own experiences and thoughts and expertise.
That if those Google searches can track to the exact timeline and time frame and backtrack. So right, we're not really sure about that, but we looked at it and said it's again maybe just distractors.
That's the consensus was, that the 227 Google search was a distraction.
Again, kind of distractor. I think some people were set at the very beginning that based on the evidence that they had seen so far, and kind of combing through some of the evidence, they kind of looked at it and said, you know what, both individuals were there at that particular address. One person was operating the vehicle under the influence, and another person is now deceased. Simple
as that. I mean, that synopsis was said so many times that you can just almost hear the jury back there saying, like, hey, this is the simplest explanation. He was suspicious. If he would have liked to know that the no ring camera, they didn't talk to the neighbors, or if it was lost, the inverted video was confusing, might be an honest mistake, but it does take effort. So that stuff's important, but it wasn't the key factor for any of them. And there's a way I think you can use all of that and couch it a little bit differently. All right, let's jump ahead a little bit more.
You said you guys came to the conclusion, or that some jurors came to the conclusion, that she hit him because she was there, he was there, and there was some kind of collision. If the defense did a better job at explaining that he wasn't hit by a vehicle, would that have changed your thoughts? Or if they focused on John sustaining injuries inside the house instead of from a vehicle? I don't understand the second part of that question, but I guess my question that will go along with this is like that. Do you think that they focus too much on the conspiracy aspect of what happened and not enough just on, look at, dude, there's no way this guy was hit by a car because that's what the science says?
What Turtle Boy just said right there. I don't know. Maybe he listens to the show. I don't know. But that's what we said throughout the whole trial. Some people didn't like it, but that's what we said throughout the whole trial. Too much focus on the conspiracy, not enough focus on the reasonable doubt, and the fact that we don't know what happened, but we know it wasn't a car. That's the thing we can be sure of, which is why I came down on that side eventually. The not guilty side, not the conspiracy side. I don't know. My thought process throughout the entire first trial was that exact argument.
I think that would have been helpful, because really creating the...
Yes, they absolutely did argue reasonable doubt. They absolutely did argue she wasn't hit by a car. They absolutely put forth that information. But there's no doubt what was highlighted and focused on was the conspiracy.
Distractors, whatever distractors that may be. Like he went inside the house. He got injured inside the house. There was the dog that bit him. There was...
Those were all just seen as distractors to them.
Injury in the weight room downstairs. All of these became kind of like theories and confusing or distractors to the jury. So ultimately...
Oh, this is good. Amy's Positive Pathway said they have better now, and he's been saying this. Okay, good.
They just looked at the facts, and the facts were there's damage to the vehicle.
So hold on. Sorry, I keep pausing it. The dog bite, distractor. Maybe he went in the house, distractor. Instead, they just looked at the facts. So they did not see those things that were testified from the witness stand as facts.
right? So a simple look at it is two individuals were there. Somebody was operating the vehicle under the influence. There's damage to the vehicle. It's a broken tail light. There's injuries to John O'Keefe, and now he is dead. Then who's ultimately at fault? The operator of the vehicle.
You keep saying distractors, and that's what they were arguing. But their entire defense is third-party culprit. So are you saying that not the most effective defense? For if you were coaching their lawyers for the second trial, like, would you say that isn't that as effective as you guys think it is?
I don't think it's as effective. I think it would have been better to focus on the evidence that the state is trying to promote, and focus on those and show the holes on those, or create the reasonable doubt based on those pieces of information. So, for example, have an expert other than the individuals that were there who could actually talk knowledgeably about the physics of damage to a vehicle. I understand the
who could they get that's better? That's what I'm saying. He's talking about anybody that votes guilty, and I'm not saying him, but any of the jurors that vote guilty, they're always going to be able to say, if the defense would have done X, Y, and Z, if they would have just done a little bit more, because the defense always needs to do more to win a case. It's a very common theme in jurors.
The ARCA group, but somebody else potentially, or clear indication that this is not a distractor. I think having those individuals
clear indication that this is not a distractor. I don't get that. I don't understand what that means. A clear indication that I'm not trying to lie to you or distract you or trick you.
Testify at the end after all the other distractors, which was the expert on animal bites, and then also the little pieces of distraction there that was created might have not helped the last person.
The little pieces of distraction, like the animal bite expert.
But the last two to go were the ARCA guys.
I think if the ARCA guys had gone before the distractors, I think it would have been better, because then it would have been more solid.
This is like, I want to just show this real quick, this part, but it's like, yeah, any individual person, this is why lawyers don't take advice from one individual person, right? When we do focus groups, we talk to a lot of people, we try to get consensus, but like, he thinks the witnesses should have gone this way. Some other juror would have thought it should have gone that way. Most of the guilty jurors probably didn't care what the order was, right? They laughed at Trooper Paul, and he said, like, all the jurors kind of laughed at him and didn't find him credible at all. Yet they still voted guilty. Some of them. It's crazy to me. And that's the point, is it's like Trooper Paul should have been a huge, huge part. Not a one-off, yeah, we all know what a joke that was. That should have been a huge part of it, right? If 2:27 a.m. search is true, it's a conspiracy, but they just thought it was a distractor. And again, the Commonwealth did well. Got to give Lally his flowers. These are all distractions. These are all distractions. Or distractors, whatever. All right, let's talk about how Dr. Russell just did not convince them. Did not convince them. And this is a case where, again, some people think that experts are great, and some jurors just believe experts because they sound smart. Sometimes, and this is, again, me and Dave and I talk about this all the time, if they're with us, they're going to like this expert. If they're not, they're going to hate this expert. And it is so true. And sometimes, and a lot of times we get in these chats, we're like, oh, there's no way somebody's not going to like this expert. Oh, yes, there is. They thought ARCA was a distractor because maybe Turtle Boy hired him. They weren't convinced by Dr. Russell. We were right that they didn't like Trooper Paul, but it didn't matter.
Anonymous for $5 and says, what did jurors think about John's arm injuries? Do any of them have dogs? That's a good question. Did any dog owners speak up and say, I own a dog, I know what dog bites look like, those are or are not dog bites?
So there were some dog owners. We did look at it. It did not look consistent with injuries from a tail light per se, but we couldn't say specifically it was from a particular type of dog, if that is the question.
So Dr. Russell didn't convince you, or Dr. Sheridan?
A little bit of convincing. I think it became suspicious when, again, it was brought to light that she volunteered her services after seeing an article. So that was
suspicious that she volunteered her services. That's exactly why the state did that. And Brennan is going to drive a bus through that. Wags, I agree with you. I think it was a collective we on purpose. But yeah, I mean, Lally did a good enough job to make him suspicious and make him think Dr. Russell was in fact a distractor.
That was
So
kind
that-
of
So
suspicious
again,
for the group.
another point for Lally, I guess, because Lally brought that up and said that I guess Lally's not as incompetent as I thought he was. That
Correct. But I always say it's a lot easier to prosecute cases than it is to defend them. Proctor had credibility until the text messages came out, then he lost it all. So we have the lead investigator that this juror said, the jury said, lost all credibility once the text came out, and they were laughing at Trooper Paul, who was their accident reconstructionist, and they still got a majority to vote guilty on a lesser included of count 2. Imagine that. And they all thought the investigation could have been better by happenstance. They didn't mark the verdict slips, which is important. He says he thinks the SJC would have changed that would have changed the SJC's mind if they would have, privately marked the verdict slips and not brought them out. I disagree. I don't think it would have changed their mind based on their ruling. How did the defense attorneys do? Okay. He answers this.
The slips independently of each other. Had we, I think it would have again changed the case and changed the decision of the SJC.
Marissa sends $5, says the jurors actually understand that the prosecution has to prove their case, that they couldn't just speculate. It sounds like there was bias against the defense, that they put experts in the stand to lie and confuse them. How did you feel about the defense attorneys?
I think the defense attorneys did a reasonable job. I think
he thinks they did a reasonable job. Is that what most of the internet was saying? And when you have really big personality attorneys and a really big conspiracy that they are uncovering and explaining, it can go either way. They can love you or they can hate you. That's just how it is. Finding consensus is not easy. Peter, will they use the same verdict forms this time? Camilla, here's what I'll tell you. I don't know, but I can guarantee you more time, thought, and energy will be spent on the verdict forms this time than they were the last time. What will the result be? I don't know. He said jurors didn't discuss the case much during the trial, thought they weren't supposed to discuss it at all until deliberations. Thoughts on that? I agree it shouldn't, but maybe we're mincing words. Maybe he was just agreeing. I'm not going to put a lot of stock in that. Allison, them saying that the two of them were there and John was dead reminds me of Murdaugh. 3 people at the kennels and 2 are dead. Christy, not to be political, but I wonder how willing a jury in 2025 will be believing cop prosecutor misconduct now that we're all living in the onslaught of ugliness at the highest levels in our country. It ebbs and flows, right? It definitely ebbs and flows. Is it plausible to now have lawyers available as jurors? Like that's their only position, only available all jury rooms in a courthouse, jury advocate. It's possible. It's unlikely for both lawyers to agree that a lawyer would be able to do that because you'd have to have some trial experience to get there. And if you're a career prosecutor, ain't no defense attorney is going to want you back there. If you're a criminal defense attorney at any point, prosecutor's probably not going to want you back there. Even past judges. I'll tell you right now, we have a key, a read on the judge. Judges are unbiased. They sit up there. We like them. We respect them. We don't want them deciding our cases. We know what their background is, right? Trooper Paul was huge, starting to think the foreman was a plant. He directed them. I don't know. Do you believe KR is being unfairly burned by the FBI investigation? She didn't hire the FBI, but this jury dismissed ARCA. No, I think she's being helped by the FBI investigation. If I had to pick one or the other, I think she's being helped. Okay, let's jump to the next clip here. Oh, they have the utmost respect for Judge Cannoni. I think that's important. Higgins throwing the phone away is suspicious again, but there were suspicions and distractions on both sides, he said. And I would say, use that as the defense. I agree. There are suspicions and distractions on both sides, but guess what? They have the burden. Jennifer McCabe, the vibe, he was kind of indifferent, not overly helpful or hurtful. Just talked about some facts, not even worth reviewing. To me, that's a huge win for the prosecution. That he was like, yeah, McCabe, she was fine, just whatever. She just discussed some facts. What he means is we believe the facts that she said. We did not see the facts that she said as a distractor or somebody lying to us. All right, next clip here.
Anticipated, some of the things that you've said about it. So thank you for sharing that. This is Stephanie sends 5 and says, what did they think of the inverted video? Would the FBI hiring Arca made a difference? Been over that. Thank you. And Nancy sends $5, says, what about Karen connecting to John's Wi-Fi when the accident supposedly happened? And the 3 flights of stairs that he went up and down. So yeah, because I always bring up the 3 flights of stairs thing. To me, that's the biggest piece of evidence. Putting John inside the house is Apple Health data shows him going up and down 3 flights of stairs. Did the Apple Health data come up at all?
I think had there been an expert to provide us some information on accuracy of that kind of data when somebody's actually walking up the stairs, or could it be mimicked by movement of the individual inside a vehicle going in?
And again, the way Turtle Boy asked this question, sure, it's a great argument for the defense in his question. That's because he's with the defense. He sees it the way, if he was on the jury, he would see it the way the defense is explaining it. But if you're on the jury and you're with the prosecution, you see it the way the prosecution said, oh, he could be driving up and down hills. And this guy who seems like he's kind of in the middle is like, well, it would have been better if we had somebody explain to us that it actually was walking up and down stairs. Turtle Boy brings up a good point that Karen Reed's wasn't. And why didn't they use that data? Is there some bad stuff in Karen Reed's Apple Health data? I don't know. Will they use it the second trial? We'll see. But from my perspective, this is how jurors see things. It can be so clear to somebody who sees it one way. And that's why I love it, because this is what I try to, get our discussions to be about. It's okay to disagree, see things differently, because there are jurors who will, and not just a little differently, but completely opposing views of the same fact, same witness, same evidence.
To a different plane, so I think those were pieces that were not very clear.
An expert obviously could have clarified that if from Apple or something, if they could find an expert, or somebody who just uses Apple Health data. For like a lot of people, personal trainers use Apple Health data for their clients. They have to use, monitor, show me that you guys got your steps in, blah, 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 blah. Nobody brought that up and says, hey, wait a minute. I use Apple Health data all the time. And I don't
So we couldn't do any kind of investigation on our own after we got some data or some evidence.
That's good. I'm glad they did.
Or testimony. But that was definitely in some of our minds. Like, we kind of wished we knew more about it. Like, does it matter if I go in an elevator? Will it pick it up? Or does it need to be, I need to actually actively be walking and then go up the stairs? So I think we kind of discussed that, or it was talked about, but not extensively. And it would have been nice, again, to have it as part of testimony with an expert witness.
Now, what if the defense had offered testimony from Karen Reed's phone that showed that Karen Reed's Apple Health data does not show that she was ascending and descending 3 flights of stairs during the time?
And yes, he says that would be helpful. I'm going to jump ahead a little because I do want to get to the end here. Solo cups, leaf blower, was bad, but not that big of a deal. The judge did come in and talk to them, said thanks, asked them to let them secure the area before they leave, but didn't talk about the case. The meetings and the texts with the prosecution witnesses and the group chats were suspicious. Again, more suspicions and distractors. That's going to be important when we talk at the end. They didn't have enough context when they did the jury view. Okay, they heard shouting from Karen Reed supporters while they were, having lunch and things like that. We'll see if that affects the protective order. Suspicious evidence that McCabe deleted just one search, didn't like Higgins. Turtle Boy lays out the Birchmore situation. I said much better synopsis than I gave. And of course the juror said, yes, it would help if we heard all of that corruption. Problem is, the way Turtle Boy explained it, it would never come into trial like that. It would never be explained to the jurors like that. It would be a much less emphatic and provable theory, because we have to be careful about the prejudice it may cause and what exactly it tends to prove or disprove. All right, let's jump to the next clip here.
Were trustable. I think it was just one of those where, what were they trying to present, right? What type of information and who they were putting up on the witness stand and using for testimony for their cause is important.
Was Alan Jackson too good? Like, was he too Hollywood? Did he come across to you guys as this guy is just a professional distractor? That this guy, did some of the jurors believe that Alan Jackson was full of shit?
Before we get to his answer, Michelle, this is what I feel like a lot of times in cases, and that's why I say, especially in civil cases, the plaintiff and the defendant usually testify. I think that's what it comes down to a lot of times, just who they believe.
No, I don't think I think that's the other thing that was interesting is we couldn't look up any kind of information on the lawyers. So some of us didn't know anything about Mr. Jackson's
But we all agree
history
that just
until
listening,
afterwards.
besides his history, we all agree that he was much more polished and flashy than Adam Lally, who is like, a dial tone, a human dial tone. Did that, like, I get the question there, like, and I'm not sure if I'm communicating it the right way. Like, did Alan Jackson almost come across as like too flashy?
I think to some of us, maybe. I think he was fine. I think it was just
To some of us, maybe he came off too smooth, too polished, expensive suit, nice watch. And again, that's why, you don't wear your best watch to a trial, but you can't help how well you present. So I don't think anything's going to change from that personally. All right.
right, though. He was more polished. He looked more professional in his delivery in comparison to that of
Adam
Attorney
Lally.
Bauer.
Yeah.
And it sounds like that was held against him. And guess what? I've heard that same exact thing. Even on cases I won, they were like, certain parts, you were almost too convincing, is what I've heard in closing argument. It's like, what does that mean? What am I supposed to do with that? It's like, but you got to be careful. And that's why I feel like YouTube has helped, right? It's like you get on in the conversation, you understand where people are coming from, even if you disagree with them. You try to figure out what it will take to get them to see it your way, right? What's important, what's not. Oh, is it because we don't understand the rules enough? Do we have to get into this? Do we have to get into that? Oh, you like this expert better. That's what being a trial lawyer is.
Since more review is needed to make a better decision. I don't understand that question. Thank you very much. Wendy sends $50 and asked about the integrity of Michael Proctor. We've been over that. Thank you, Wendy. Melissa sends $10 and says, hi, Ronnie. Thanks for doing this. What did jury members think about Lucky's testimony? And I kind of know the answer to that because I interviewed about it. And I believe you told me that he was the least effective witness that you thought of all the witnesses. Why?
Because he was not able to report on the information where he actually struck a basketball hoop and he didn't report himself. So because he didn't report himself and he wasn't very consistent with his testimony, or he had inconsistency with his testimony, then it was determined that he was not or I basically believe that he was not a credible witness.
Wow, that's wild. Do you guys think?
I get it, right? But it's crazy because it's like when you impeach certain witnesses with inconsistencies or issues with their testimony, they're like, oh yeah, I just thought, she was kind of indifferent and I believe it as facts. But other ones, it's like they totally throw out what they said. These are individual people that you have to convince. I also kind of came away thinking in this interview that the best argument to try to get another hung jury is the conspiracy. You get one or two to buy in and they're locked in with you, they'll never convict her. So it's like almost like, what do you want to go for? When they heard FBI, Nagel say FBI, they thought maybe there's another case or civil. To me, that rings bad for Karen Reed. I don't think, I'll just tell you right now, if I heard FBI involved at all, I would not think good for the defendant because that's very rarely the case. As we talked about when I brought my dad on when we found out the FBI was involved. So it's not a good thing for Karen Reed. All right, they discuss ARCA a little bit more here.
Says distractions. He's saying that the other jurors, right, viewed all of this stuff about the conspiracy and the dog and, Jennifer McCabe's Google search as distractions. That's what he's talking about. Let's see. Carrie sends $10. Say, you're saying Karen needs witnesses to explain the injuries couldn't come from a car. That was ARCA, but they weren't credible because the jury thought they were from an insurance company. So do you think Karen paying for experts like that would be more believable? I don't understand the question, Carrie. Do you?
To me, it sounded like, would it be more believable if she paid for him herself instead of this unknown third-party agency?
They're just trying to figure out if some of the, if part of the defense paid for that kind of investigation. And like I said, we didn't know where this was coming from, where these experts were coming from. And it was great. They gave their credentials, but at the same time, we were kind of confused on why were they giving this data piece. And I get it. They were trying to create a reasonable doubt. And for some of us,
they were trying to create reasonable doubt, right? Just the language feels like they felt like the defense lawyers were trying to pull one over on them. That's the vibe I'm getting.
Who were on the fence, it did create that reasonable doubt. But for those who were already determined with one decision, it didn't help because, again, it felt like it was a distractor to prevent them from siding in one direction.
That pretty much confirmed that people made up their minds way before the ARCA experts ever testified. And calling them earlier, I don't think that would have mattered. And everything became a distractor once you make up your mind. Roberta said, watching you since Elizabeth Holmes, do you believe you became a better, I thought it said battered at first, lawyer by following all these cases? Absolutely. Absolutely better. Absolutely not battered. I'm happier and healthier than ever. But yes, I learned so much from following these cases, and I wouldn't have near the interest if it wasn't for all you guys talking about it with me. Nellie, Peter, is a juror allowed to ask a family/friend about the evidence in a trial without discussing the case, a spouse in IT about Google searches? No. That would be doing outside research on their own. And I've actually had this happen to me very recently. One of my buddies was on a jury. He was texting me. I was like, whoa, whoa, whoa. It's like, text me after. We'll talk all about it. But yeah, it absolutely happens. All right. All right. Next clip here.
Out how John O'Keefe died. I don't know the answer to that one.
I don't know. I don't know the answer to that.
Yeah. Lulu sends $10.
Other than I think it was just a head injury. So the head injury and hypothermia, right?
I think the question was something like, did you feel you had to figure out how John O'Keefe died?
But who caused the head injury? And there was, we also kind of said some theories in the deliberation where.
By the way, so this right here is a very important point for, what I'm going to talk about, how I would set up closing. And again, I thought about this for 5 minutes. They've been thinking about it for years. So they're going to come up with much better ways to do this than I did. But these are the kinds of things that stick out to me because from my experience, that's usually how it is. If there is a way to theorize or think about something, jurors usually will do it. And they'll come up with every different scenario.
And there was, we also kind of said some theories in the deliberation where he could have fallen himself. So he could have fallen back and by his own accord and end up exactly where he was without Karen striking him. So, and that's where he laid to rest, unfortunately. So who knows, right? Maybe from a standing height, he could have sustained that head injury and fell on his head. But if he was so inebriated, who knows?
So people were just making up theories about it sounds like, right?
They were making them up, but they were thinking, what are all the ways this could have happened? What happened to this guy? You can tell a jury it's not their job to figure it out or figure out who done it. You can tell them that 1,000 times. They're still going to want to try to figure out what happened. And they're going to take everything they heard. They're going to apply their life experiences and their knowledge. And they're going to say, well, then what do we think did happen? Which is why you have to give them reasonable alternatives.
Yeah.
Okay. All right. I mean, that's wild.
Yeah, we were kind of thinking of what are the possibilities. And it didn't seem like, based on the evidence that we were provided, it seemed like we were already given the theory that caused the injury, which was she backed up. That's why there's a broken taillight. He has an injury. He's dead.
Okay. Lulu sends $10.
I think he said ultimately that's where we landed, something like that. Okay. Then they talked about how it was unnecessary for the kids to testify, said it was unprofessional. Did the jurors feel bad when McCabe talked about intimidation? Yes, some of them absolutely did. To me, that is a huge win for the Commonwealth and a huge problem for the defense. They need to make sure they don't get into that. Because a lot of people were like, and that's another thing I said, I don't know, this could cut both ways. Because they were like, oh, Jackson drove a truck through that. He made them look so bad talking about that intimidation, blah, blah, blah. When in reality, he confirmed some of the jurors felt bad. They did. Kept saying things like, if the defense could have proven this or that. To me, that's tough language to listen to, but I appreciate the honesty. I really do. And it's not surprising to me. I think that's how a lot of jurors think. All right. So that's the bulk of what I want to show in the interview. But as you can see, it's 3 hours long. So if you want to check out the whole thing, Turtle Boy's got the whole thing posted on, I think on his Twitter, X, whatever, and his YouTube page to listen to the whole thing uninterrupted by me constantly. So let me get to just kind of my thought process on what I would do differently if I was the defense, especially thinking about closing argument and how I would set up this case. I would draw a diagram or a timeline and basically say, here's what we agree to. Because I don't think there's any way of getting around to Karen was driving, John was in the car, they had both been drinking, and they went to 34 Fairview. Okay? So they were all there. And then we know some people were inside. You know, who exactly was inside? Maybe we don't know everybody, but we know some people were inside. And we know John wanted to go hang out with those people inside. And they had some conversations. So we know all that. So that would kind of be the beginning of the timeline, I would say. I would write it in green or blue, be like, we all agree to the blue stuff, right? Then on the back end, I would end the timeline basically with the time that Karen Reed connected to John's Wi-Fi. We all agree she was home. Even the Commonwealth agrees she was home. That would have blown Adam Lally's timeline out of the water right there. Okay. But you start with that. And then in red or whatever color you want, what happened in this time period? That's what we are trying to figure out. What happened in this time period? And that's when you start to hammer reasonable doubt. That you have to be morally certain about what happened there. Now, you know that Karen Reed was driving. How do you know that? And I would explain how we get to everybody agreeing and what a moral certainty looks like by using Karen Reed was driving, John O'Keefe was there, they were drinking, they went to 34 Fairview, and people were in Fairview. All the testimony lines up. Everybody admits it. The car data shows that she was there and they drove there. The cell phone data shows that she was there and they go there. And there's no real arguments or distractors or suspicious events when we talk about that they were both in the car and they were there or who was in Fairview. That's morally certain. That's how you can vote, yes, that is true, that happened. But let's talk about this red area. Morally certain or no other reasonable explanation. There's no other reasonable explanation. Karen Reed was in the car. John O'Keefe was in the car. These people were at 34 Fairview. No other reasonable explanation. We know that that's what happened. But let's talk about these, minutes here. Because there are multiple explanations. And it's the prosecution's job to prove to you what happened in those minutes. So let's talk about the different possibilities of what happened in those minutes. And we'll start with the prosecution's theory, which is that Karen Reed hit John O'Keefe with the car. Can you be morally certain? So there were witnesses that saw Karen Reed in the car outside. There's car data that said Karen Reed was outside. Phone data that shows Karen Reed was outside. There is not a single witness who said they saw Karen Reed hit John O'Keefe with her car. There is no cell phone data that shows Karen Reed hit John O'Keefe with her car. There is a backup of, the showing the backing up of the Lexus. But what does that prove? Are you morally certain about what that proves? Because let's talk about the timing issue that Turtle Boy talked about. And you chip away at the moral certainty of that. There's a broken taillight. Are you morally certain that broken taillight actually happened at 34 Fairview? That's when you can get into the conspiracy. That's when you can get into the Proctor text. If they're able to get into the Sandra Birchmore, they lock on that was a suit that she heard herself, and they locked on that this was Karen Reed. This is the MO of these detectives, and they're going to cover up if anything has to do with a cop. That's their MO. And who's inside? Cops. Proctor texts. Everybody knows everybody. Conspiracy in Canton. Go ahead. Knock yourself out when it gets to the taillight. So can you actually be morally certain about that taillight? And even if you are morally certain that the taillight broke in that way, or broke that night at 34 Fairview, would that have caused the injuries to John O'Keefe? We got Trooper Paul. Seriously? Let's talk about what he said and go into his theory in detail, in painstaking detail. And then let's talk about ARCA. Carr didn't cause these injuries. Maybe they'll be able to ask Dr. Russell this time too. Carr did not cause these injuries. That makes no sense. The science does not back it up. Is this morally certain? No. In fact, it's scientifically impossible. So if something is scientifically impossible, how can it be morally certain? How can you be morally certain about what happened? And that's the prosecution's theory. Did they really prove it to a point where you can be morally certain, just like you can be morally certain at who was in that house and who was in the Lexus and who drove the Lexus? Can you be morally certain about that? Well, let's talk another option. That a dog bit him, he was beat up in the house, and this was a big cover-up. You don't have to be morally certain about this one. Is that a reasonable theory? Is that a reasonable option? Is that a reasonable explanation of the injuries and what happened? We've got an expert who said those are dog wounds. We have text messages that absolutely make it seem like John O'Keefe went into that house. We have evidence, the cell phone data that said he was going up and down stairs. Let the prosecution talk about the hills, and of course they're going to have arguments against all this. I get that. But you put out all your evidence right there that this happened inside Fairview and they dumped his body there. They all walked right by it and didn't see it. The only real explanation for that is it happened inside that house. Is it morally certain? I don't know, but it doesn't have to be. It just has to be a reasonable explanation when it's our theory versus their theory. And if there are multiple reasonable explanations, that's a reasonable doubt and it's over. It's not guilty. It's not guilty if their theory is not morally certain. If there are other reasonable theories, it's not guilty. That's what reasonable doubt is. But guess what? That's not the only theory. This could have been a horribly tragic accident where Karen Reed dropped John O'Keefe off. He had had some stuff to drink. He tripped, he fell, he hit his head, and he passed away. That's a possibility. That's horrible. That's also a reasonable explanation. A guy is found in the front lawn. I would say most people that end up hitting the front lawn trip and fall. That's how they get there. If you believe that's reasonable, if they didn't prove to you that that's absolutely what did not happen in this case, because they needed to prove that didn't happen, that he didn't trip and fall. And guess what? His head injury is a lot more similar with hitting the rock hard ground than it is with hitting a car, because there's nowhere on the car that he hit his head and nobody came and told you that he hit his head. Or of course, a dog bites him and he falls. Another explanation that he fell, and if that's even reasonable, it's not guilty. But then you finish with this. You finish with this. The reason none of this can be morally certain and can be proven to you is the last reasonable doubt, and why reasonable doubt covers this case. It's because of the horrible, and Brianna, it's a good question, but how did the car get damaged? It's a good question. And the jurors that are with the prosecution already and think that's the case, that's what they're going to hold on to. And if I'm the prosecution, I hammer that home, but I'm not going to reiterate the conspiracy. I'm not going to go down that road again when I'm talking about the trip and fall. I'm not. You want to know why? I'm going to simplify it for them. I'm going to give them a few simple explanations because they were willing to consider it even with a broken taillight the first time. And I think any jury would reasonably consider that. Now, they may say absolutely that didn't happen, and that's fine. And they can say that. But I'm going to give them some simple explanations to where if they think it's reasonable that that happened, that's reasonable doubt. But the final point of reasonable doubt in this case is the investigation. It was so bad. We can all agree with that. And that's why we can't be reasonably certain about anything. That's why we have all these distractions. We have all these suspicious things happening. They didn't go into the house and look at it. They didn't swab the right places for DNA. They collected stuff in red Solo cups and Stop and Shop bags. The chain of custody is a mess. They didn't talk to witnesses in time. They didn't record witness interviews. The lead investigator is sitting here saying X, Y, and Z. We got Higgins going to the police station at random times. So whatever happened, we can never prove it. And guess what else? They can never prove it. The difference is the law says they are not going to get up here and tell you we have to prove anything. But I'm going to sit here and tell you, and the judge is going to tell you they do. They have to prove something. Their people are law enforcement. Their people are the investigators. Their people are the ones that screwed that up, and it should not be held against Karen Reed. You can't sit back there and say, we got to give the benefit of the doubt to the Commonwealth. Well, maybe it's okay. Maybe, by happenstance, they didn't find the pieces till the next day. No, that can't be how it is. That can't be how it is. The benefit of the doubt goes to Karen Reed, not to the Commonwealth. And this investigation was so bad, they can't prove anything to you to a moral certainty. 5 minutes of thought, right? Is it perfect? No. Are there holes? No. Are people that think she's guilty in the chat? I appreciate your comments. But what happened to the broken taillight? I get it. What about Karen Reed screaming at him and leaving these voicemails? I get it. What about saying nobody came into the house? I get it. That's all good evidence for the Commonwealth. Let them put that in their closing. But give them some reasonable options. Crack open theirs. Explain why it can't be to a moral certainty. And then explain why nothing can be proven to a moral certainty in this case because of the investigation. Period. That's it. And if they convict, they didn't believe you. And they believe the prosecution witnesses. And that's just how it is sometimes. That's it. That's just kind of my thought, right? That's just kind of my thought, the way I would look at it, the way I thought about the case the first time, right? That's really what I thought about the case the first time. go ahead. The conspiracy can be one of the 4 things you argue, but I don't think it should be the one argument you make 4 times. That's kind of how I would look at it in this case. But that's it. I got to head to, oh gosh, we got questions. Let me go through these questions here. Peter, can you cover the Michigan versus Marcella child Dester case? If you guys want it, let me know. Well said, counselor. Good closing argument. Thank you, Rebecca. I figure the people here watching this channel would like it. But I'm sure there are going to be some people that absolutely hate it. Audrey, the translation of Occam's razor is do not complicate things unnecessarily. That is not the same as the simplest solution. It implies there can be necessary complications. Okay. I appreciate it. Jennifer, if you guys want this case, let me know. Let me know in the comments. Lead up. Peter, you underestimate your brilliance. You would add so much by joining the defense team. No, I think they've got it covered, and they can feel free to watch any of my YouTube videos. I don't hide a lot. I don't hide a lot. Bella said, this is why Peter would be my lawyer. Thank you, sir. Yes. Hey, you guys need a lawyer. You let me know, right? Wrongful death, car accident, something horrible happens to you or somebody or your family member, call me. I would love to be your lawyer. With that closing, let's hope the defense is watching your videos. I doubt it, but I do think probably some people that maybe talk to the defense, watch the videos, maybe. Kim, I love Labradors. Thank you for continuing covering this case. Your legwork is appreciated. Sunlight is the best disinfectant, quoting Reed. It's a good point. I agree. Rebecca, this is your drop the mic moment, Peter. While I am dropping the mic and I am heading out of here, thank you, Michael, for gifting more memberships. Aussie Law Nerd said ASAP update. Tomorrow morning, 8 a.m., there will be an ASAP Rocky trial update. But we're almost 2 hours. It's too long of a closing argument. 1 hour. All right. You guys are good. I appreciate you so much for being here. Hit that like button if you haven't already, but I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.